Rodney Eugene Lockett, a victim of prosecutorial misconduct. Hello, my name is Grady Marshall, and I'm an ambassador for Rodney Eugene Lockett, a brother who is serving 13 natural life sentences for a crime that he never committed, a veteran, a man that served in the United States Army. Rodney Eugene Lockett, an Army veteran, was actually exonerated of the crimes he was alleged to have committed through serological laboratory testing, yet Mr. Lockett remains in custody of the government since the year 1985. On February the 22nd, 1985, at approximately 9 p.m. in St. Petersburg, Florida, females were abducted and sexually assaulted by a lone assailant. Semen was recovered from one of the females by means of a sexual assault victim examination kit, which is known as SAVE. Laboratory testing of that semen conducted by FDLE, Florida Department of Law Enforcement, revealed that the attacker of both females had a blood type of A, which is Exhibit 1. The problem with this finding by the crime lab is that Mr. Lockett is blood type AB, Exhibit 2. These test results of the semen recovered from the victim are consistent with the sworn statements of Dola Coleman, Exhibit 3, and Ada Lockett, Exhibit 4, which verifies that Mr. Lockett was sleeping at Mrs. Coleman's residence on the couch at the time of the abduction and sexual assaults of both females. We will now digress and start with Exhibit 1, and for the record, this is Exhibit 1, which shows that on 1A, blood type was A, and on 2A, blood type was O. At no time was Mr. Lockett's blood type detected upon neither one of these alleged victims. Okay, Exhibit 2 is actual court transcripts, which I will read from the record that was stated in open court. Question: does there appear to have been any tampering with the package since you sealed it? Answer: no. Question: and I would ask that you open the packet and see if the contents are intact. Mr. Crow: I think we are already stipulated to the chain of custody, Your Honor. If you want to go into it, that's fine. Mr. Taylor: yes. Thereupon the witness opens the packet. Question by Mr. Taylor: are those the same items that you analyzed? Answer: yes. Question: did you have occasion to find or to form an opinion as to what sort of blood the person had? Answer: yes. Question: and the person, as you understand it, is Rodney Eugene Lockett? Answer: that's what the tube is labeled. Yes. Question: what sort of blood type does Mr. Lockett have? Answer: I typed it at AB blood type. Those are the exhibits of 1 and 2. As we progress with this, the primary cause of Mr. Lockett's wrongful conviction, as noted by both key witnesses, Dola Coleman and Ada Lockett, the prosecutor's office of Pinellas County, Florida, misled Mrs. Lockett and Mrs. Coleman into believing that no prosecution of Mr. Lockett was going to take place due to the lack of evidence implicating him, Exhibit 3 and 4. Accordingly, Mrs. Coleman and Mrs. Lockett did not testify in Mr. Lockett's defense at his trial. Another problem occurred when the St. Petersburg Police Department assigned Detective Paula Zittelberg to investigate the abduction and sexual assault of both females. Detective Zittelberger had a tendency to submit incomplete or non-existent investigations as to crimes that were assigned to her. A review of Detective Zittelberg's employment file reveals that departmental action was taken against her for failing to properly investigate assigned cases, especially where physical evidence and eyewitnesses were involved. This will be Exhibit 5. This poor work performance on the part of Detective Zitterberg contributed to Mr. Lockett's conviction due to the fact that the detective would submit findings to the prosecutor's office which were incomplete or unsupported by an investigation of the evidence, which would be in Exhibit 5. We went through Exhibit 1 and 2. Exhibit 3 is a sworn statement from Dola Coleman, which reads, "On the night of February 22nd, 1985, my husband, Winston, and I drove around and saw Rodney Lockett sitting down by a tree on 18th Avenue South and 22nd Avenue South in St. Petersburg, Florida. He was very drunk. We stopped and talked with Rodney, and he told us that he had been stopped by a policeman earlier that day, but was let go. Rodney stated that his friend Rock had his car. Because Rodney was so drunk, my husband and I helped Rodney into our car and placed him in the back seat. The three of us returned to our home. Earlier that day, I had cooked collard greens, and the three of us ate dinner together. After we ate dinner, Rodney went to sleep on my couch for a few hours. When Rodney woke up, the three of us went to take him back to the little tavern to get his car. At first, we couldn't find the car because it was not parked in the same place where Rodney had said he left it. When we did finally find the car, it was backed in on the bar's property with the front facing 18th Avenue South. The keys were in the car, but Rock was not there. Rodney stayed and talked to some people outside the bar. I remained in the car, but my husband stood outside our car and spoke with several people that he knew. My husband and I were going to follow Rodney home, but a friend of my husband's needed a ride home, so we were not able to follow Rodney home as planned. Rodney left the bar before us. It was approximately 11 or 11:30 p.m. because my husband and I left the bar parking lot around midnight. I told Rodney's mother, Ada Lockett, on several occasions that Rodney was at my home the evening of the rape kidnapping incident and to have someone contact me, but no one ever contacted me, not any lawyers, state attorneys, or police. I never received a phone call, never received an interview, nor was I allowed to testify at Rodney's trial because the district attorney assured us that they had no concrete evidence against Rodney and he was sure that Rodney would be acquitted. This is the sworn statement of Dola Coleman. Exhibit 3. Exhibit 4 is Mrs. Lockett, Rodney's mother. Exhibit 4. And this is what it says. On the night of the incident, my god sister Dola Coleman told me Rodney was at her home, drunk, lying on her sofa. The state attorney was aware of this, but did nothing about it. I was kept out of the courtroom, being told I was going to be a witness. I was never called. I was told there was not enough evidence and Rodney would be freed. Excuse me. I feel I was kept out of the courtroom for a reason. A friend of his was driving his car that night. That's Exhibit 4. As we move to Exhibit 5, which is a copy of the City of St. Petersburg, Florida employee notice, which is a disciplinary notice which was instigated against Detective Paula Zitterberg. It says, comments, during the first week of July 1985, I pulled at random 23 case files from Detective Zitterberg's file and found that 9 cases were behind in follow-up dictation. This is a violation of Journal Orders 4-1, Section 1, Item 8, productivity or workmanship. not up to required standards of performance. Action taken: counseling and 1-day suspension for Detective Paula Zittelberger. Has employee been warned before about this offense? Yes. How? Orally and written. When? 29 February 1984, 4 September 1984, and within the past 6 months of the filing of this notice in July of 1985. Detective Zittelberger has been counseled previously by Sergeant W. Waters and received a written and oral reprimand. She was also counseled by Sergeant B. Williams within the past 6 months for the same problem. As we move forward, I would like to state that the primary cause of Mr. Lockett's wrongful conviction, as noted by both key witnesses, Dola Coleman and Mrs. Ada Lockett, the prosecutor's office of Pinellas County, Florida, intentionally misled Mrs. Coleman and Mrs. Lockett into believing that no prosecution of Mr. Lockett was going to take place due to the lack of evidence implicating him. Accordingly, Mrs. Lockett and Mrs. Coleman did not testify in Mr. Lockett's defense at his trial. Another problem occurred when the St. Petersburg Police Department assigned Detective Paula Zittelberger to investigate the abduction and sexual assault of both of these women. Detective Zittelberger had a tendency to submit incomplete or non-existent investigations as to crimes as they were assigned to her. A review of Detective Zittelberger's employment file reveals that the department action was taken against her for failing to properly investigate assigned cases, especially where physical evidence and eyewitnesses were involved. We just read Exhibit 5. This poor work performance on the part of Detective Zittelberger contributed to the findings by the prosecutor's office, which were incomplete or unsupported by an investigation of the evidence. Now, recently, it has been discovered that the St. Petersburg, Florida Police Department has deliberately hid the laboratory test results of a pubic hair recovered from one of the alleged victims in this case, which conclusively demonstrates that Mr. Lockett is innocent of the sexual assaults of 2 white girls, for which he is currently serving 13 natural life sentences. On August 8, 2013, pursuant to a Public Records Request Act, which is known as the Florida Sunshine Law, made with the Florida Department of Law Enforcement, the FDLE responded to Mr. Lockett's request with a laboratory report dated July the 16th, 1985, which was published on July the 30th, 1985. The first day of Mr. Lockett's trial in this case, and was not sent to the lead detective Paula Zittelberger until August the 1st, 1985, the last day of Mr. Lockett's trial for these sexual assaults, and was never brought to the court's attention. The laboratory report demonstrates that a pubic hair originated from a non-Negroidal individual. Mr. Lockett is black. Additionally, the pubic hair did not originate from neither one of the victims. This deliberately concealed evidence corroborates the other evidence which conclusively demonstrate that Mr. Lockett is innocent of this crime. The fact that the real attacker was blood type A, where Mr. Lockett is blood type AB. The city of St. Petersburg, Florida, refuses to correct this injustice, instead preferring to keep a lid on this horrible act of injustice. These are not conjectures, these are facts. These are not opinions. These are what is read into the record. What can you do to help? You can help by supporting Mr. Lockett. You can contact him directly, Rodney Lockett, prison number 917795, E1219, that's his dorm, Zephyr Hills Correctional Institution, 2739 Gall Boulevard, Zephyr Hills, Florida, 33541-9701. You may also file complaints with Bernie McCabe, the prosecutor, at emailing him efarrar@co.pinellasflorida.us. Reference the 6th Judicial Circuit Court case number 85-2110, and let Mr. McCabe know that you object to the wrongful prosecution and imprisonment of Rodney Lockett. And you may also contact the Honorable Governor Rick Scott via email at rickscott@eog.myflorida.com and let him know that you object to the wrongful prosecution and persecution of a man who stands innocent, even though all the serological testing and all of the testing that they have done upon the victims does not implicate Mr. Lockett in any way. We thank you for your support. We ask you to please get involved. We ask you to stand in the gap for a man who is wrongly convicted, spending 13 natural life sentences behind bars for a crime that he did not commit. Thank you.
Show the address.
And the address is Thank you, and God bless. This is Elmer Marshall wishing each and every one of you a blessed new year in the year 2015. And let's make this a year of jubilee for Rodney Eugene Lockett. Thank you very much.